the district court is not in session. And we'll see Alan Lawson, judge, presiding. All persons having business for this court, draw near, give attention, and shall be heard. God save the United States of America. Florida, and this honorable court. You may be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. Before I announce the panel, I'll tell you that we are going to take HINES v. State of Florida first. That's the case that Judge Orfinger is on. So, counsel want to go ahead and get in place while I do introduce the panel. On my right, we have Judge David Monaco. On my left, Judge Richard Orfinger, and as introduced, I'm Alan Lawson. We have 2 criminal cases and 3 civil cases on the docket. Each side will get 15 minutes on the criminal cases and then 20 minutes per side on the civil cases. We're going to hear the add-on case, as I said, HINES v. State first, and then we'll proceed in the order of the docket with Lazar Gomez v. State next, and then Sigurdsson. And at that point, we will take a recess, a break, and we'll invite any counsel who want to join us for coffee in the Lawyers' Lounge to do so, and then we'll come back and finish with the cases set for 3 o'clock. So whenever you're ready, we'll call the case of HINES v. State.
Your Honor, Patrick Hinchy on behalf of Mr. HINES. May it please the Court. This is an appeal from an order denying a motion which sought relief from a judgment. James Francis HINES III entered a plea of nolo contendere to 2 charges. The first charge, burglary of a dwelling, a felony. Second charge, violation of an injunction, a misdemeanor. If I may, Your Honors, I'm going through some pertinent facts here that will come of issue as we discuss this significant law. It was declared void, the violation of the injunction, count 2 in the information, was subsequently declared to be void ab initio by Judge Hamrick. It was declared to be void ab initio because it was signed by Judge De La Roche.
Let me ask you this.
Yes, Your Honor.
You cite in your brief to the case of Miller v. State, but you also seem to argue that manifest justice was not the standard that should have been applied below. Didn't we actually decide that issue contrary to your position in Miller? Under similar facts? Under very similar facts, yes, Your Honor. However, significantly different facts that I will point out. New evidence in Miller v. State, I assume this is 814 Southern 2nd, 1131. New evidence did not help the defendant when he did not claim innocence of the charge. There was no manifest injustice found, and there was no probable acquittal if tried. In Miller v. State, additionally, in this case, in the instant case. But the legal issue there in Miller was whether, when the motion is based on newly discovered evidence, and it's a motion, and the newly discovered evidence, according to the motion, indicates that there is a basis to withdraw a plea, whether the standard the trial court's looking at is manifest injustice or simply the newly discovered evidence standard. And I think in Miller we said that the defendant has to show manifest injustice. And is that the standard? Is that the correct standard, manifest injustice?
Well, if I may, Your Honor, I believe it is the standard, but under these circumstances, these particular set of facts, the newly discovered evidence standard of itself is applicable because there was evidence presented in the evidentiary hearing, a full evidentiary hearing at the 3850 hearing before Judge Hutchinson, that is applicable.
Well, showing that there was newly discovered evidence would allow you to bring a claim that would otherwise be time barred. But once you do that, don't you still have to show that based on that evidence there's a manifest injustice that would lead to conclusion that the plea needed to be withdrawn?
I believe typically you would, Your Honor.
Okay, and why is it that you don't think we need to do that in this case?
Because in this case, this isn't mere recanting of testimony. This is the fact that one of the charges to which the defendant pled nolo is void ab initio.
Well, it's kind of hard to tell that, don't you think? There were 2 injunctions, yes, one of which was declared void ab initio. I'm looking at the information, and the information just simply says he did intentionally and unlawfully, after having been served with an injunction for protection against repeat violence, go to the residence, school, place of employment, and so forth of Rhonda Joyce Mangrum. Both
Yes.
of the injunctions, did they not, prohibited him from going to Rhonda Joyce Mangrum's place of business or home, right?
Absolutely. However,
If the information doesn't identify one of the injunctions or the other. He was prohibited one way or the other from going to that place, wasn't he?
that's correct.
And he went there.
He
He
stipulated
played
that
Nolo,
he-
so I assume he went there.
Yes, Your Honor.
So I guess I'm having a hard time figuring out then, well, first of all, why we're even here. But
Well, fair question, Your Honor. The reason that we're here is because the totality of the circumstances surrounding the plea is what it takes to have a knowing, intelligent, and voluntary plea to a criminal charge. The information referred, and if you look at the hearing that Judge Hutchison conducted, refers to the other injunction, the one that was valid, even though this one that he pled to, and I know it's a question as to whether which one he pled to. If you look at the 798, which is also of record, only the injunction as to Ms. Mangrum, the void injunction, is referred to as a basis for the charges.
so where's the manifest injustice if he indeed was prohibited from going to that place by one of the other injunctions, and he went there? Well, I don't see the manifest injustice, and I agree with Judge Lawson. I think manifest injustice is clearly the standard here.
Even if manifest injustice is the standard, I believe manifest justice has been shown below. The conviction of a violation of the void ab initio injunction is what is at issue. And Mr. Hines would contend that that was, in his mind, what he pled to. That was what was discussed in the information. That's what was discussed in the 798. The other injunction was not mentioned until the post-conviction motion.
Well, but as a practical matter, when we look at the manifest injustice, it seems to me that you're focusing on the tail and missing the dog here. The dog was that he was charged with burglary of a dwelling for going to the woman's house, breaking a window out, and going into her house, all of which is illegal, irrespective of the existence of an injunction. The injunction, that's a second-degree felony. The injunction was merely a misdemeanor. And so I'm having a hard time seeing in the scope of the way the criminal system really works why his concern wasn't really properly focused on the second-degree felony charge and resolving that somewhat short of 15 years in prison versus the misdemeanor charge.
Well, I believe it was concerned with the second-degree felony, and he ended up doing 30 months in prison for that. While he was there, a member of the JQC and a member of the governor's office came to him and alerted him to the fact that the information, that one of the violations was void ab initio, was proper to attack its validity.
I think that disjoinder that Judge Orfing is referring to is the fact that you're trying to withdraw the plea as to the burglary charge, and the burglary charge has nothing to do with the injunction. I mean, it's not listed as an element that he violated the injunction while he's committing the... I mean, it's just... They didn't have to prove an injunction at all, nor is it pled to establish burglary.
And that's where the factual basis is at issue. The factual basis for the acceptance of the burglary plea is that he was intending to commit an offense therein. That's a required element of the offense of burglary. When he...
Didn't he commit a criminal mischief therein?
Well, that's in question. There was never an actual...
The state doesn't have to plead what offense he intended to commit therein, and they didn't, correct?
They did not, however...
Certainly never pled that he broke in simply to violate an injunction, did they?
No, they didn't. It is left in doubt. I believe that they implied that he was seeking self-help to return some personal possessions to himself. And he admitted that he did break a window. But that falls short of proving all elements of burglary, and it falls short of providing a factual basis for the acceptance of a plea to burglary.
But the factual basis that was offered by the state from the 15-year-old girl that was in the house was that he broke the window out and that he partially got through the window before, I guess, he got scared off and went away. And doesn't he give up the right to contest whether or not this was just an act of vandalism versus an act of trespass versus an act of burglary by virtue of entering the plea if those facts that the state proffered and reasonable inferences that could be placed thereon would demonstrate a factual basis for the plea?
Your Honor, intent cannot be inferred without a trial according to Florida Statute 8.10.07. The element of the offense is intent to commit an offense therein. That must be established by the state, typically in a trial. That is where a jury could infer intent. However, under the circumstances of a plea, that wouldn't be proper to infer intent. There should be a factual basis for the acceptance of a plea. The intent to commit...
but he had the ability, the state proffered that he broke the window out and that the young lady said that he was inside. The state indicated that they thought that he was resorting to some form of self-help, presumably to retrieve some of his personal property. And he didn't dispute any of those facts as part of the plea.
They were stipulated to, however, there were the facts that were presented in the police report was perhaps that he entered the building, and it was perhaps that he broke a window, but even there was another witness.
The logical link that I'm having a problem with is you say that you have newly discovered evidence, and that evidence relates to this injunction that you say was void ab initio. How does that allow you, even if you establish that that is newly discovered evidence, how does that allow you to now go back and challenge the unrelated factual basis for a plea to a different crime?
Well, I would just contend that it's not an unrelated factual basis. It provides the requisite element for burglary by which the court accepted both pleas. Both pleas were entered simultaneously in the same hearing.
You're saying that the state's proffer of evidence was that he violated this injunction, and that's what the crime that he intended to commit when he was in or attempting to broke into the home? I
believe that is what the court and the state relied upon, and the defendant.
Did they say that? Is that part of the record? Can you show me where?
In the judge's hearing and Judge Hutchinson's hearing, he specifically does refer to that injunction as being. No, Your Honor, I can't. I'm just trying to think.
Let me ask you about the basis for your argument that you even meet the newly discovered evidence standard, and that is that that standard requires the exercise of diligence. And I would just assume that these are all matters of record, that the judge entered a written recusal order and that that's dated, and that the injunction that he entered thereafter is dated, so that you can see from the record that the injunction was entered after the judge recused himself, which would make it void. Is that correct?
That is correct.
Okay, so why does the fact that someone notified you of something that's public record after the deadline for a 3850 entitle you to bring a newly discovered evidence claim when you could have looked at the file and found that information out at any point in the prior years?
Yes, Your Honor. Because of the inherent power of the judiciary, when an injunction is issued by the court,
but in the standard that you didn't know it and could not have found out with the exercise of reasonable diligence or something similar to that.
Yes, Your Honor. But
you can look at the court file and see that the injunction was of questionable validity based on matters of record. Why couldn't you have, with reasonable diligence, found that out long before someone from the JQC came in and interviewed your client?
Well, it would refer to the time of the entry of the plea as well. And at that time, I think it would be reasonable to rely on what is in the record and during the plea negotiations between the state and the defendant, and to assume that the injunction were valid. And in fact, the court relied on that at the time of the acceptance of the plea. And that in itself is where the newly discovered evidence. Had the court known that, I think that the court, just to speculate, would have wanted to determine which injunction he were accepting the plea to. And in this circumstance, when there are simultaneous pleas being entered to two different crimes, one of which is later determined to be violation of a void ab initio injunction, the other of which relies on that void ab initio injunction actually being a violation to allow that to have a required element of that second offense, that under those limited circumstances that the plea should be able to be withdrawn. Miller v. State, a First District Court of Appeal that's not briefed, I just found this in 2008, said additionally fundamental errors may be raised for the first time on appeal. The conviction of a plea of guilt to armed robbery where the facts and the information support only simple robbery was fundamental error, where the record affirmatively demonstrates the crime to which the defendant pled guilty could not have occurred, fundamental error occurs. In this case, the defendant contends that the fundamental error is that he relied on the void ab initio injunction as a basis. So did the court, as for a basis to accept his plea of guilt to the burglary. Error is fundamental in nature where manifest injustice would otherwise occur. Manifest injustice includes convicting defendant for offense which he could not have been convicted of. Thank you.
19 seconds.
Your Honors, Ann Phillips on behalf of the State of Florida. It's the State's position that Mr. Hines has failed to demonstrate an abuse of discretion by the trial court in the trial court's determination that there was a failure to demonstrate a manifest injustice. A voluntary plea would waive any non-jurisdictional defects. Mr. Hines stipulated to the factual basis, and in fact I would like the court to note that the 798 does mention the case number 30611 in which the temporary injunction and then permanent injunction of Ms. Pope. So both people are named in the 798, which the trial court took judicial notice of in determining, in making its decision. If there are no specific questions from the court, we would ask that you affirm.
Okay, thank you very much. Anything else? Okay, thank you.